Good afternoon. It's a far cry from when I was in law school and I was the first person to carry a notebook, and now I see a whole group of them. And during the Q&A, I get to field questions from all of you instead of a single judge, so that'll be an interesting experience. I practice in a part of Florida that's called the First Judicial Circuit. Florida has 67 counties. We have 20 judicial circuits, and we have 5 district courts of appeal. That'll become a bit important in a few moments. Types of cases I handle, you already know about. It's a wide variety, but it's all criminal defense. My practice is state court, not federal court, and so today's presentation will involve what I do in the state court system with law and neuroscience, specifically SPECT brain imaging. And that's supposed to be a video explaining how the legal system works. And as you can see, it's technologically challenged, so we'll do this the old-fashioned way. The legal system looks like an upside-down letter Y. It starts when somebody is either investigated or arrested. For legal purposes, it's when they're arrested. It goes through various different procedures with different names. There's an arraignment, which is formal charging. There will be a pretrial conference or motion hearings, and then ultimately a case will come down to a point of decision that'll range from 90 days if the case is a misdemeanor offense, minor in possession of alcohol, or DUI, first offense, no prior record, no aggravators. And if it's a felony, it'll take about 6 months, 175 days. And practically speaking, most cases are continued once or twice simply because you don't have all of the information that you need. Florida is a discovery state, so we file a document known as a notice of discovery, and then we get a discovery exhibit in response. Ultimately, cases either go to trial or they settle. And that's basically the flowchart of Florida criminal law, without any question marks. Now, how does legal representation begin? Well, it begins with a phone call, usually, and it can be a panicked family member, it can be the defendant, it can be a number of different ways, and then we go through a process very different from most other law firms because of what we do with brain imaging and neuroscience. We do an intake interview. Now, this intake interview is a screening tool because one of the threshold questions we have to know as a private practice law firm is, can the person who's calling afford us? And that's a very practical question. It's not a very academic question, but frankly, if they can't afford us, they're not going to be able to afford what we can do for them. Unfortunately, that's just how it is. I'll never forget when I was in law school and I asked a visiting lawyer what the most important thing he could learn on an initial consultation was, and to my utter horror and surprise, he said basically what I said a moment ago, whether or not they can afford to pay a legal fee. That's the reality. After that, we then go to an initial consultation, and when I'm reviewing the intake interview, which can be 2 to 10 pages, I'm looking for red flags. Now, when it comes to law and neuroscience, what am I talking about when I say I'm looking for red flags? Well, I know if there are enough of them, we're going to have that person go in for a brain imaging study, and we're going to find out if it appears that they have holes in their head, much like you see spinning around on this slide. We ask obvious questions, mental health history, substance abuse, but then we go a little bit further because there are other red flag indicators such as traffic tickets. If somebody has 12 traffic tickets in a 5-year period of time, that's actually very important. That's a red flag. We also want to know if they have criminal history. Early in my career, I began asking questions. Why does somebody have 3 DUIs in a 2-year period of time? That's not exactly a good idea. Why is somebody getting 17 prior felony convictions over a 12-year period of time? That's a major red flag. Criminal history is huge. We also want to know civil case history. If somebody is running out filing petitions for protection from domestic violence or being a respondent to domestic violence charges, just to give one example, that's a red flag. When you see 9 domestic violence related civil petitions, that's also a very important indicator. And then finally, my part of Florida is up in the Panhandle. If they put another military base up there, it's probably going to sink. So we look at military deployments because one of the counties in the area I practice has a very innovative diversion court known as Veterans Court. So I want to look at all these different things to see if that person flags. And if they do, we're probably going to send them to Amen clinics in Atlanta, Reston, Virginia, or over in California. And they're going to do a full-blown diagnostic evaluation using various different tools of psychiatry, psychology, and brain imaging. Now, you've all heard about the reasonable person as a standard in law, right? Well, I posit that a reasonable person with reasonable behavior has a reasonable brain. Therefore, they should have reasonable brain images. And here you have 4 views with that first one on the left. The top is actually the front of the brain, so you're looking from bottom up. And there's some different views, and as you can see, it's relatively smooth. Now, I had a case recently I'm going to share with you, and I got tired of using John Doe and Jane Doe, so I thought we would talk instead, because I have to anonymize the information, of course, I thought we'd talk about Catfish Jack. Now, Catfish Jack was charged with a sex offense. Under Florida law, we have different levels of offenses, and they accrue a certain number of points. The nature of the offense by itself automatically caused him to score 56 points. Well, what does that mean? Anything above 44 points must be a state prison sentence. In addition to that, it would carry sex offender registration. The actual charge was an undercover sting operation where he had inappropriate contact with someone who was posing as a 14-year-old girl. In fact, it was a law enforcement officer, and that's why he got arrested. And when we did the brain imaging, that's what his brain looked like on one of the surface imaging sets. Very big difference when you compare the two. Now, does this mean that Catfish Jack is not guilty? Does it mean he's not guilty by reason of insanity? Not at all. For all practical purposes, you could actually take this entire section of the diagram out of the equation, because we were going to go to a sentencing hearing or direct sentencing with a plea bargain. The plea bargain in this case was an adjudication of guilt, felony conviction that would destroy his military career, and did, as well as 30 months in the state prison and sex offender registration for the rest of his life. So we did the brain imaging study, and we went to a sentencing hearing mindful of the local rules. Now, here's some more images of the deep brain images, just to give you a feel for what we're looking at. This is what a healthy, normal set of, or a single brain image looks like. On average, there's going to be some variation based on age, gender, other factors. This is what his look like. And they're very different. A lot of stuff in there that you wouldn't find in what I posit as a reasonable person's brain. So then we looked at the Florida grounds for mitigation under the rules of criminal procedure, because the point system is based on one half of the rule, and then you have grounds for mitigation. We went to a hearing, and we called 2 different witnesses to testify to different things. The rule itself says we only have the first 3. However, in my particular circuit, we're part of the 1st district that says we have to prove that the specialized treatment needed is unavailable in any other forum. In other words, the defense has to scour every single Department of Corrections prison and figure out if they have the specialized treatment that this individual would require. It turned out that we had a witness to testify to that effect. This is part of what I call a defense pre-sentence investigation. The reason it's highlighted is because right away, when the charging document was filed, that L7, that level 7, that means 56 points. Now, I knew this before the document was even filed, so we began very early on in the process so that we could show he was amenable to treatment to get him evaluated. So within a week of being represented, he went up to Amen Clinic in Atlanta, had a diagnostic evaluation done, got a 3-ring binder that was enormous in terms of what the recommended treatment plan was, and it covered everything from supplements to counseling specific sex offense types of treatment, medication, everything from soup to nuts. And finally, I'd like to know if you have any questions.